The question that we are going to go over in this lesson is freely available for download on the National Conference of Bar Examiners website, which is www.ncbex.org. If you'd like access to more practice questions like the one we're about to go over in this lesson, simply head over to the National Conference of Bar Examiners website and visit the section on preparing for the exam. From here, you can download tons of free practice questions directly from the National Conference of Bar Examiners. This is an awesome free resource I highly recommend everyone check out. Additionally, if you would like explanations to more bar exam questions in the format of this video, you can always head over to our website at www.studicata.com. But with that, I'm really excited to get into this lesson with all of you, so let's just go ahead and jump right in. In this lesson, we're going to go over a constitutional law essay question from the July 2012 multi-state essay exam. So step one, the first thing we always want to do with these types of essay questions is head down to the bottom of the essay first and take a quick look at the call of the question. Oftentimes the call of the question is going to give us really important information to consider as we begin to actually read our fact pattern for the first time. So if we take a look at this call of the question, we see it asks us three questions. Question number one asks, is the act a valid exercise of Congress's power to regulate interstate commerce? Explain. Question number two asks, assuming that the act is a valid exercise of Congress's power, may the act constitutionally be applied to state agencies as employers? Explain. Question number three asks, does the 11th Amendment bar the employee's lawsuit in federal court against the state agency? Explain. So this is a really great call of the question. Gives us all kinds of important information that we can use as we begin to actually read our fact pattern for the first time. So we can kind of break this down question by question and try to develop a little bit of an issue spotting checklist we can use as we begin to actually read our fact pattern for the first time, starting with question number one. Is the act a valid exercise of Congress's power to regulate interstate commerce? So this is kind of given to us, right? The issue is handed to you in the call of the question. This is a clear commerce power analysis. Commerce power analysis. Right? Anytime on a constitutional law bar exam essay question, we see Congress is passing a law. They're enacting some type of legislation. The question we always have to ask to ourselves is, well, where is Congress getting the power to pass this law in the United States Constitution? We know Congress can't just show up and pass any kind of law that they want, right? They have to act pursuant to the powers that have been granted to them in the U.S. Constitution. Specifically, we're really looking at Article 1, Section 8 of the Constitution, right? This is where most of the grants of power to Congress are located, right? So we're always looking at Article 1, Section 8, where in this section of the Constitution does Congress have the power to enact this type of legislation? Now, fortunately, this call of the question actually just gives it to us. They point exactly to where in the United States Constitution Congress is acting, right? It tells us, Article 1, Section 8, the Commerce Clause. Is the act a valid exercise of Congress's power to regulate interstate commerce? Well, we know Article 1, Section 8 grants Congress the power to regulate all foreign and interstate commerce. So the question is, when we see Congress is passing this law, is it within their power under the Commerce Clause? Here we say a federal law regulating interstate commerce must either regulate the number one, right, channels of interstate commerce. Number two, the instrumentalities of interstate commerce. Instrumentalities of interstate commerce. Or number three, an activity that has a substantial effect on interstate commerce, right? If any of these three prongs are met, then we're going to say Congress does have the power to regulate that activity under their Commerce Clause power under Article 1, Section 8 of the U.S. Constitution. So we're looking at number 1 and number 2 first, right? Is Congress regulating a channel of interstate commerce? Is Congress regulating a channel of interstate commerce or an instrumentality of interstate commerce? If they're regulating a channel of interstate commerce, right, that's valid. If they're regulating an instrumentality of interstate commerce, that is also valid. So what are the channels of interstate commerce? This would be like the pathways through which interstate travel and communications pass. Think about things like interstate highways, interstate waterways, interstate airways, and interstate phone lines, any wires that are transferring money or communication across state lines, right? Phone lines, wires that travel across state lines. This would also be the channels of interstate commerce. So if you see that Congress is passing a law that's regulating waterways, airways, roadways that travel through interstate commerce or across state lines, or wires, phone lines traveling through interstate commerce, right? Any of this stuff, any channel, any pathway through which interstate travel and communication pass, Congress can regulate in those areas, right? Also, the instrumentalities. This includes the persons, things, and other objects that are moving in interstate commerce. So it'd be like the airplane itself and the employees on the airplane, right? The passengers on the airplane. This would be like the boat and the occupants of the boat that are traveling through interstate commerce, right? Any object, people, anything, person or thing that is moving in interstate commerce. This is the instrumentalities of interstate commerce, right? This is how we get a lot of the federal aviation law that we have that says, airplanes have to follow these safety protocols, and there has to be, these specifications that are met, and pilots have to have this many whatever years of experience, right? All of that. That's all regulations of the instrumentalities of interstate commerce. So if we see Congress is regulating the channels of interstate commerce or the instrumentalities of interstate commerce, that's a usually really straightforward analysis. The answer is, well, yeah, they can do that. That's very well established law. Where things can get a little bit more complex is where we see Congress attempting to regulate activities that have a substantial effect on interstate commerce. Because we have to identify, okay, well, what activities have a substantial effect on interstate commerce? And really, this whole analysis comes down to whether the activity being regulated is commercial or non-commercial, economic or non-economic. So the first thing we want to do if we get to this third prong, which usually we're going to get to the third prong, right? If we're in a bar exam essay for constitutional law and a commerce power analysis, usually it goes to the third prong because this is where you get the most rich type of analyses, right? So usually this is what the area of the commerce power that the bar examiners like to test, right? It'll be whether the activity has a substantial effect on interstate commerce. If you're trying to determine, does this activity have a substantial effect on interstate commerce, the first thing you want to ask is this activity commercial or economic in nature, or is it non-commercial, non-economic? So is it economic or commercial in nature, right? And I always kind of think about the distinctions between Wickard v. Filburn and United States v. Lopez. So we can kind of just write like Wickard v. Filburn and Lopez v. United States, right? Wickard v. Filburn, remember we have the farmer who is growing wheat for his own personal consumption, right? But the idea is growing crops, even if it's for your own personal consumption, that's still a commercial activity. When we think about farmers growing crops, that is something that we can see is really commercial or economic in nature, right? This is why people grow crops, right? By and large, growing crops is a for-profit commercial business, right? It's commercial or economic in nature. That's kind of Wickard v. Filburn. United States v. Lopez would be possession of guns in a school zone. Right? When we think about the possession of a gun in a school zone, it's hard to really make a connection between the possession of a gun in a school zone to like commercial activity. Right? We don't usually associate public schools where kids are learning and education with like commercial activity. Right now, if it was possession of guns in like a workplace, that could be a little bit different, right? A workplace with 100 or more employees, laws that look like that, well, maybe that does have some impact or relationship to, being commercial or economic in nature. But the possession of a gun in a school zone really doesn't bear relationship to like economic or commercial activity. So you always want to kind of categorize step one if we're trying to determine whether the activity being regulated by Congress has a substantial effect on interstate commerce. Well, is this more like Wickard or more like Lopez? Is this commercial, economic, or is it non-commercial, non-economic activity? That's step number one. Step number two is if we find, and this is why step number one is important, if we find that it is a commercial or economic activity, we can apply the aggregation doctrine. Right, we get the aggregation doctrine. Right, this is from Wickard v. Filburn, right? So remember, in Wickard v. Filburn, we have this farmer who is growing wheat for his own personal consumption. And if we think about one farmer growing wheat for himself, for his own personal consumption, and we're asking ourselves, does that activity by itself have a substantial effect on interstate commerce? One guy growing wheat for his own use? The answer is probably not, right? That one farmer who's only putting the wheat that he grows in his own mouth for his own consumption, well, that wheat never crosses state lines. How is that having a substantial effect on interstate commerce? And what the court does in Wickard is it says, well, look, Wickard by himself, this one farmer by himself, sure, maybe that alone does not have a substantial effect on interstate commerce. But if we look at this activity in the aggregate, if we look at every farmer in the state and we think about every farmer growing wheat and we apply this aggregation effect, we can see how all the farmers in the aggregate do have a substantial effect on interstate commerce. So because this is an economic or commercial activity, we can apply the aggregation doctrine and find that in the aggregate, this does have a substantial effect on interstate commerce. Of course, in a decision like Lopez, the court is not allowed to apply the aggregation doctrine because that's a non-commercial activity. So you can't say in the aggregate, does possession of a gun in a school zone have a substantial effect on interstate commerce? You have to just look at it in a more isolated way. And Congress is not going to be able to show that possession of a gun in a school zone has a substantial effect on interstate commerce, right? That's just not going to work. So really, the whole analysis comes down to whether the activity is economic or commercial or not, or it's non-economic, non-commercial. Because if it's economic or commercial, we can apply the aggregation doctrine. In the aggregate, almost any activity you're going to be able to show in the aggregate has a substantial effect on interstate commerce, right? As long as there's that rational basis there, as long as it's conceivable that there is a rational basis on which Congress could conclude that the activity in aggregate substantially affects interstate commerce, right, then it's going to be satisfied. So again, the whole analysis really comes down to identifying whether the activity is commercial or non-commercial, economic or non-economic. That's going to be the big part of that analysis. So as we go to read the statute, what we're really looking for is what is the activity Congress is regulating? Is this commercial? Is this non-commercial? Right, of course, too, we're looking, does this regulate the channels of interstate commerce? Does this regulate the instrumentalities of interstate commerce? Right, if it's regulating the pathways through which interstate travel and communications pass, like highways or phone lines, then we don't have to discuss all of this stuff, right? So if it's actually regulating, if we see that this law Congress is passing is regulating the channels or the instrumentalities of interstate commerce, we don't have to worry about substantial effect, Wickard and Lopez. But most likely, right, the bar examiners we know are going to want to test this third prong of the analysis. So if we see it is an activity outside the scope of the channels or instrumentalities of interstate commerce, then we're going to have to identify whether that activity is commercial or non-commercial. If it's commercial, we can apply the aggregation doctrine, and we'll be confident there that the activity does have a substantial effect on interstate commerce, meaning it's a valid exercise of Congress's power under Article 1, Section 8. On the other hand, if it's non-commercial, non-economic, we can't apply the aggregation doctrine. We can only uphold that law if Congress can show a direct, substantial economic effect on interstate commerce in isolation, which it's usually not going to be able to do. So it'll probably be an invalid exercise of power under, or unconstitutional, right, under Article 1, Section 8. But that is question number one. That's kind of what we're going to look out for as we read the fact pattern there. Which takes us to question number two. Assuming that the act is a valid exercise of Congress's power, may the act constitutionally be applied to state agencies as employers? Okay, so question number two might be a little bit more tricky for some students, right? The issue here is less obvious than with question number one. I mean, question number one directly asks, is this a valid exercise of Congress's power to regulate interstate commerce? It tells you this is a interstate commerce clause analysis. It gives you that in the actual question. Question number two is a little bit less direct. Some students might not be able to obviously see what this issue is. And if that's the case on a constitutional law question, it's often helpful to just try to bucket at least like what major category it falls under. Remember, if you haven't seen our constitutional law issue spotting video, I would highly recommend watching that because we break down this kind of process in a lot of detail. But if you remember from that video, we talk about kind of the three major categories of constitutional law, right? If we're thinking about the three major categories we could encounter on a bar exam essay, we have the power of the feds, we have federalism, and we have individual rights. Usually we can kind of bucket questions and facts into these three major categories. Power of the feds being anytime we see Congress, the President of the United States, or a federal court taking action, we're asking, does this federal actor have the power to take this action? This would be like question number one. We see Congress is trying to pass a law. Congress is a federal actor. They're trying to pass a law. Do they have the power to pass that law under the Commerce Clause? Right? So that's kind of how we would bucket question number one. Federalism, we know, is about the relationship between the federal government and various state governments. Right? Federalism usually deals with conflicts between the state government and federal government. So if we see any conflict between the federal government and state government, we know it's a federalism issue. And that takes us to individual rights. We all know what individual rights are. If somebody is asserting that they're guaranteed protections, First Amendment, 14th Amendment, right? Free speech, things like equal protection, due process, free speech, religious freedom, some guaranteed protection in the United States Constitution has been violated by the government, has been infringed upon by the government, right? That's an individual rights issue. So clearly, if we look at question number two, it's not an individual rights question. We can scratch that off. We're not seeing anything here about, an individual. We're asking whether the act can constitutionally be applied to state agencies, right? We're not seeing anything about an individual asserting, that their guaranteed protections are being infringed upon. So you can scratch that out pretty quickly. Next, we see that there's like this mention of Congress, and we know Congress is a federal actor, right? When we see Congress taking action, we're always thinking, well, do they have the power to take this action? But remember, that's question number one. Question number two is asking, assuming that the act is a valid exercise of Congress's power. That's basically saying, assume that the power of the Fed issue here is taken care of. Assume that it was a valid exercise of power. Right? So it's not really a power of the feds issue because it's saying, look, assume that that's taken care of. Assume it's satisfied. Assume this act is a valid exercise of Congress's power. May the act constitutionally be applied to state agencies? Right? So we're asking, can we apply this federal law to state agencies? So that's clearly going to be a federalism issue. So at least in our heads, we can start thinking about federalism issues, right? Is there a conflict between state law and federal law? Could this be supremacy clause, preemption issues? Could there be a dormant commerce clause analysis going on? In both of those cases, we would need to see a state law in the fact pattern. It looks like here we're dealing with a federal law, so it's probably not going to be a supremacy clause or preemption issue, so you kind of cross that out. It's probably not dormant commerce clause. We'd only be applying dormant commerce clause if we saw the state a state government trying to regulate interstate commerce. Here, Congress is regulating interstate commerce, or at least trying to regulate interstate commerce. So it's not dormant commerce clause because we don't see the state trying to do this. We're asking, can this federal law be applied to state agencies? So, we know it's in the federalism category. We can kind of think in our head about other federalism issues, but to really know, we'll have to read more. We got to see what's going on. We got to know what this statute is about. And kind of once we see what the statute is, then we might be able to identify more specifically what federalism issue this is raising. But at least for now, we know it's a federalism issue. We have our frame of mind more narrowed in as we're reading and thinking about question number 2. Okay, which takes us to question number 3. This is another one that's just given to us, right? Question number 3, it tells us what the issue is. We're looking over at question number 3. Does the 11th Amendment bar the employee's lawsuit in federal court against the state agency? So this is a power of the feds issue. Does the court, the federal court, have the power to hear this case? Right? Well, if it's barred by the 11th Amendment, they don't have the power to hear this case. And that federal actor, the federal court, does not have the power to hear this case. So this is a kind of category 1 issue, but it tells us, right? So we don't really have to go through the categories because it's asking whether the 11th Amendment bars the action or not. So we know, okay, it's just an 11th Amendment state sovereign immunity analysis. 11th Amendment issue. So we know this gets triggered when we see a private party, right? A private party is suing either a state, right? A state agency, or a state official in federal court, right? If we see a private party suing a state agency, or state official in federal court, we have to think about the 11th Amendment. So it does look like the basic requirements here are satisfied. We see in question number 3, it's a employee lawsuit. We're assuming the employee is a private party, right? So we have an employee's lawsuit in federal court against the state agency. So we know at least the 11th Amendment is triggered here. We know that typically these types of lawsuits are barred, right? When we have a private party suing, a state agency in federal court, we know that these types of lawsuits are barred by the 11th Amendment unless an exception applies, right? And if we were dealing with a state official, we know there's some additional exceptions to think about, but here we don't have a state official, we have a state agency. So there's really only 2 exceptions where the 11th Amendment immunity would not apply here. And that's going to be if the state agency consents, thereby basically waiving their 11th immunity protection, or we have congressional authorization, right? Congress is abrogating state sovereign immunity under the 11th Amendment clearly and expressly pursuant to its power to enforce guaranteed protections of the 14th Amendment. So if we see congressional authorization, right, which could be a play here because we see Congress is passing this law. So maybe Congress is authorizing this, which would be an exception to the 11th Amendment, right? Or maybe we'll see that this state agency is consenting. They're waiving their immunity under the 11th Amendment. Now, we know if neither of these exceptions apply, right, then the 11th Amendment is going to bar this type of lawsuit, right? A private party suing a state agency in federal court is prohibited by the 11th Amendment. That is what the state sovereign immunity clause under the 11th Amendment is all about. It provides 11th Amendment immunity to the states, state agencies, and state officials unless an exception applies, right? When we have a private party suing a state official, or state agency in federal court, which is happening here, we see the call of the question tells us it's a private party suing a a state agency in federal court, we know that's barred unless an exception applies. We have consent and congressional authorization. So as we read the fact pattern and we're thinking about question number 3, we just want to make sure, neither of these exceptions apply, right? Is there consent or is there congressional authorization? If neither exception applies, again, we know that 11th Amendment prohibits this type of lawsuit. There's going to be immunity for the state agency. That case needs to be dismissed from federal court, okay? So that's question number 3. So we're really just looking out for exceptions because it's not a state official, it's a state agency. The only exceptions we really have to worry about are consent and congressional authorization. So we're going to be looking out for those exceptions as we think about question number 3. Question number 2, we're in issue spotting mode. We don't know exactly what it is yet. We're confident it's probably, unless we have a state law given to us in the fact pattern, it's not going to trigger dormant commerce clause or supremacy clause issues. So it's going to be some other ancillary issue under the federalism umbrella. We'll be looking out for that. Can this federal law be applied to this state agency? And question number 1, we need to look at the actual language of the law being passed by Congress. Is it regulating channels, instrumentalities of interstate commerce? If so, we know it's valid. If it's trying to regulate some other activity, the question is, does that activity have a substantial effect on interstate commerce? There we'll want to know if it's economic or commercial or non-economic or non-commercial. Once we make that determination, we can know whether or not we're applying the aggregation doctrine, and that's going to take us to our conclusion for question number 1. So this is kind of our issue spotting checklist. This is everything we're looking out for as we begin to read the fact pattern. So from here, we're ready to actually read the fact pattern, starting with paragraph number 1. Paragraph number 1 tells us that Congress recently enacted the Violence at Work Act, what we're going to call the Act. Okay, so we have an act that does appear to be about violence. So immediately, we're thinking, because we want to know what the subject matter of this regulation is all about. We're thinking about, whether this involves a channel of interstate commerce, an instrumentality of interstate commerce, or some other activity that has a substantial effect on interstate commerce. Well, we see the subject matter of the act is going to be about violence at work. Okay, we have to keep reading though. We don't know. We don't know enough yet. So let's see what this actually says, what the actual law says. And we want to think as we read this, is this regulating an instrumentality of interstate commerce, a channel of interstate commerce, or some other activity that might have a substantial effect on interstate commerce? So we read on. Title 1 of the Act provides that an employee who has been injured in the workplace by the violent act of a coworker has a cause of action for damages against that coworker. Okay, so Title 1 of the Act provides that an employee who has been injured in the workplace by the violent act of a coworker has a cause of action for damages against that coworker. Okay, so we're not seeing how this is regulating the channels or instrumentalities, right? This is not regulating the pathways through which interstate travel and communication pass. This isn't like an interstate highway regulation or a phone line regulation, right? We're not seeing how this would be an instrumentality of interstate commerce, right? The person and things moving in interstate commerce, right? It just says employees who have been injured in the workplace, right? We're not seeing the movement across state lines in that language yet, right? We have to keep reading, though, to Title 2 of the Act. Title 2 of the Act imposes several duties on employers subject to the Act and create a cause of action against employers who do not fulfill those duties. Section 201 provides that all employers, including all states, their agencies, and subdivisions. Okay, Section 201 provides that all employers, including all states, their agencies, and subdivisions, who have more than 50 employees are subject to the Act. Okay, so right there, this is going to our question number 2 issue. And we might starting to be seeing kind of what our question number 2 federalism issue is all about. Right? We're now seeing a federal law that provides that all employers, including all states, their agencies, and subdivisions who have more than 50 employees are subject to the Act. So in our head, we should start to be thinking about maybe the commandeering limitation, right? We know the Supreme Court of the United States has held that Congress may not commandeer the states to regulate private conduct. If you think back to New York v. United States, the Supreme Court struck down a federal statute that commanded states to regulate private disposal of hazardous waste, right? And in this vein, remember, under the taxing and spending powers, Congress can encourage state action, but it can't rise to that level of compulsion or commandeering, right? So here we're seeing that the Congressional Act here, right, under Section 201 is providing that all employers, including the states, who have 50 or more employees are subject to this act, right? So we're going to be thinking to ourselves, okay, is this rising to the level of commanding the states? Is the federal government commanding state action here? Are they forcing the states to adopt some sort of regulatory scheme? And when we're thinking about this, we don't want to forget about Garcia v. San Antonio Metropolitan Transport Authority. This is a really important case here to consider. If we think back, we know the Supreme Court of the United States there held that Congress may regulate the states on the same terms as private actors. Garcia upheld application of the federal minimum wage and maximum hour law to both public and private employers. Remember, if we're thinking about federal minimum wage law, we know that federal minimum wage law applies to state agencies because it applies even-handedly to state agencies and private actors, right? That's Garcia v. San Antonio. So here, what we're seeing when we look at Section 201 provides that all employers, including all states, their agencies, and subdivisions, who have more than 50 employees are subject to the act. Well, that sounds a lot like Garcia and federal minimum wage laws. Federal minimum wage law isn't saying only the state agencies and their employers have to follow this. They're saying, look, everyone's got to follow this. Private companies, private parties, private employers, and state agencies who happen to have employees, you all have to follow this. Everyone's following this the same way. Right there in Garcia, the court saying, well, that's not commanding the states to take action, right? That doesn't rise to the level of commandeering the states because that's applying even-handedly to private parties and state agencies. Okay, so that's what this looks like reading this language. It looks more like Garcia, kind of our federal minimum wage case, right? That we know because it applied equally to public and private employers, the court upheld it as not commanding state action. Okay, so we have to keep reading though. The next section of the Act, Section 202, requires employers subject to the Act to train employees on certain methods of preventing and responding to workplace violence, to conduct criminal background checks on job applicants, and establish a hotline to report workplace violence. Okay, so we just see some requirements that the people who are subject, the employers who are subject to this act are now going to have to follow. They're going to have to train employees, conduct background checks, and establish a hotline. Okay, that's Section 202. Moving on to Section 203. Section 203 provides that if an employer subject to the act does not fulfill the duties imposed by Section 202, an employee who has been injured by the violent act of a fellow employee may recover damages from the employer for the harm resulting that the violent act. Section 204 provides that any action brought pursuant to Section 203 may be brought in federal or state court, and that if brought in federal court against a state, its agencies, or subdivisions, any defense or immunity under the 11th Amendment to the United States Constitution is abrogated. Okay, so we see this 11th Amendment abrogation clause in the statute. Basically, we know this goes to our congressional authorization exception when we get to our 11th Amendment analysis. Remember, a private party suing a state agency in federal court is barred under the 11th Amendment unless the state agency consents or they have congressional authorization to bring the suit. We know Congress can abrogate 11th Amendment immunity if it does so clearly and expressly, acting pursuant to its power to enforce the guaranteed protections of the 14th Amendment. Here we see we do have Congress attempting to clearly and expressly abrogate state sovereign immunity. It says in Section 204, right here, Section 204 provides that any action brought pursuant to Section 203 may be brought in federal or state court, and that if it's brought in federal court against a state, its agencies or subdivisions, any defense of immunity under the 11th Amendment to the United States Constitution is abrogated. So it's a clear and express attempt to abrogate state sovereign immunity, but there's a problem. It's not an abrogation acting pursuant to Congress's power to enforce guaranteed protections of the 14th Amendment, right? Here we know that Congress is acting pursuant to the Commerce Clause. That's question number one. They're acting pursuant to Article 1, Section 8 of the Constitution, right? They're not acting pursuant to its power to enforce the guaranteed protections of the 14th Amendment. So because they're not acting pursuant to their power to enforce the guaranteed protections of the 14th Amendment, they're acting pursuant to Article 1, Section 8, the commerce power. We know even though they're trying to abrogate state sovereign immunity clearly and expressly, this is an invalid attempt to do so, right? Because they're not acting pursuant to the 14th Amendment, to the enforcement, to Congress's power to enforce the guaranteed protections of the 14th Amendment. So this is an invalid abrogation attempt. They do it clearly and expressly, but they're acting pursuant to Article 1, Section 8, Commerce Clause. They're not acting pursuant to enforce the guaranteed protections of the 14th Amendment. If this was like a civil rights statute, right, about equal protection, then they could do this. If they were enacting this law to protect the guaranteed protections under the 14th Amendment, something like equal protection, right, then they could have abrogated the state sovereign immunity clause. But just pursuant to the commerce power, that's not like a civil rights case where we would see, okay, Congress can abrogate state sovereign immunity. So without that, because they're acting pursuant to Article 1, Section 8 commerce power, not the guarantee to enforce the guaranteed protections of the 14th Amendment. This is just an invalid attempt to abrogate immunity. So that's going to be your analysis for question number 3, which means because congressional authorization was invalid, unless the state agency consents to the lawsuit, it's going to be barred under the 11th Amendment. Takes us to the next paragraph. The House and Senate committee reports on the act note that Congress passed the act under its power to regulate interstate commerce. To support its use of that power, Congress found that acts of workplace violence directly interfere with economic activity by causing damages to business property, injury to workers, and lost work time due to the violent acts and their aftermath. The House report estimated that total interstate economic activity is diminished by 5 to 10 billion per year as a result of losses associated with workplace violence. Okay, so this all goes to prong number 3 in question number 1, right? So this whole paragraph is like question number 1, prong 3 of our commerce power analysis, right? They're trying to show that the regulation of this activity does have a substantial effect on interstate commerce, right? Essentially that the violence at work that they're trying to preclude from happening here results in $5 to $10 billion per year in losses that could affect interstate economic activity. Right, basically, interstate economic activity is diminished by $5 to $10 billion per year as a result of losses associated with workplace violence. So this is all about, look, they're saying, we know we're not regulating the channels or instrumentalities directly of interstate commerce, but we are regulating an activity, violence in the workplace, that does have a substantial effect on interstate activity, on interstate commerce, right? And they're relying on basically the aggregation. They're saying, look, if we look at workplace violence in the aggregate as a whole, right, it diminishes economic activity by $5 to $10 billion per year. So that is a substantial effect, but they're using the aggregation doctrine. So to be able to use the aggregation doctrine, it has to be an activity that is economic or commercial, right? So is workplace violence an economic or commercial activity or not, right? That's the big question here. If it is, we can apply the aggregation doctrine. This law will be upheld. If it's not a economic or commercial activity, workplace violence is not economic or commercial, then we cannot apply the aggregation doctrine. And all of this stuff basically is off the table because you can't look at it in the aggregate if it's a non-commercial activity. Therefore, you're not going to be able to show that this has a substantial effect on interstate commerce. In other words, Congress does not have the power under Article 1, Section 8 to pass this law. So that will be your analysis for question number 1, which takes us to our next paragraph. After the Act's effective date, an employee of a state agency was injured in the workplace by the violent act of a disgruntled coworker. The state agency, which has over 100 employees, conceded that it had not implemented the measures required by Section 202 of the Act. Accordingly, the employee has sued the state agency and United States District Court to recover damages for the harm caused by the act of workplace violence. The state agency has moved to dismiss the lawsuit on 3 grounds. Congress did not have the power to enact the act, Congress did not have the power to apply the act to state agencies, and the 11th Amendment bars the employee's lawsuit. Okay, so this last paragraph is just giving the kind of the rise to the lawsuit, right? And the state here is basically conceding that it had not implemented the measures required by Section 202. They're saying, hey, look, yeah, we're in violation of this statute, but the statute itself is unconstitutional, right? Congress didn't have the power to enact the act. Congress didn't have the power to apply the act to us. And the 11th Amendment bars this lawsuit. We can't be sued in federal court for this. So that is the analysis there of these 3 calls of the question, kind of just reiterated in this last paragraph. So with this, though, I think we've identified all the major issues. From here, we'd be ready to actually write our essay. But what we'll do is just take a look point by point at what the bar examiners were looking for from examinees, starting with point number 1, which was worth 50% of the essay. Here, the bar examiners were looking for examinees to conclude that the act is a valid exercise of Congress's power to regulate interstate commerce under the Commerce Clause if the court concludes that the act regulates an economic activity with a substantial aggregate effect on interstate commerce. So yes, this ended up being just a basic Commerce Clause analysis, right? So we look at our 3 prongs. We know that if we're trying to decide whether a federal law is within Congress's power under the Commerce Clause, we know a federal law regulating interstate commerce must either regulate the channels of interstate commerce, the instrumentalities of interstate commerce, or activities that have a substantial effect on interstate commerce. It was pretty clear here that Congress wasn't regulating the channels or instrumentalities of interstate commerce, right? They're not regulating the pathways through which interstate travel and communications pass. This is all about workplace violence. They're trying to require employers, right? Bigger employers who have 50 or more employees to take these actions, right? To train employees, to conduct criminal background checks, to establish a hotline report, right? That has nothing to do with the channels, the pathways of interstate commerce. So when we're thinking about the instrumentalities of interstate commerce, which includes persons and things in interstate commerce, this statute doesn't directly single out only the people and things that are moving in interstate commerce. It applies to all employees. I mean, some of those employees might be traveling in interstate commerce, but some might not be, right? It doesn't specify in any way like the airline pilots or the airplanes, right? It doesn't single out employees who are moving through interstate commerce. It applies to all employees equally. So it's not the instrumentalities of interstate commerce. It's not regulating the channels of interstate commerce. It's not regulating the instrumentalities of interstate commerce. Here, what Congress is trying to say, what they're pointing out in this whole paragraph is, yeah, we might not be regulating the channels or instrumentalities directly of interstate commerce, but we are in the aggregate, right, relating activity that has a substantial effect on interstate commerce. And they talk about what the effect of workplace violence is on interstate commerce, right? Congress found that the acts of workplace violence directly interfere with economic activity by causing damage to business property, injury to workers, and lost work time due to the violent acts in their aftermath. They're saying this has a substantial effect on interstate commerce. They estimate that the total interstate economic activity is diminished by $5 to $10 billion per year as a result of losses associated with workplace violence. They're saying in the aggregate, workplace violence causes tons of loss in interstate commerce. That's why we are saying that this activity has a substantial effect on interstate commerce. That's why we can regulate it with this statute. So the whole analysis was whether or not this was actually an economic activity. Right. And I think arguments could have been made either way here by applicants, right? By examinees taking this. You could have gone either way. You could have said workplace violence is economic. You could have said it's not economic. As long as you used, facts to support this, you would have been fine either way. Right. And that could have gone either way. On one hand, right, if you think about it, workplace violence, violence itself isn't necessarily something we think of as commercial or economic in nature. But when we think about violence in the workplace, in an office where business is being done, well, that might be commercial or economic in nature for all these reasons Congress is laying out. So I do think you could have said, look, violence in the workplace is commercial. United States v. Lopez, possession of a gun in a school zone. Well, that might not be commercial in its nature because that's possession of a gun in a school zone. But we talk about possession of guns or violence in the workplace. That's a different analysis. And we know that workplace violence, anything that's happening in the workplace, we can make an easier connection to that being commercial or economic activity. If it's commercial or economic activity, we can apply the aggregation doctrine. And we can say, based on all these facts that were given in this paragraph, that in the aggregate, this does have a substantial effect on interstate commerce because Congress estimates $5 to $10 billion in losses in the aggregate. So if we find that it is a commercial activity, we can apply the aggregation doctrine and say, yes, this is a valid exercise of Congress's power to regulate interstate commerce under the Commerce Clause because it was economic activity. And when we look at this in the aggregate, we apply the Wickard v. Filburn aggregation doctrine. We can see it costs $5 to $10 billion in losses in interstate activity, economic losses. So that is where we get to the conclusion for point one, which was worth 50% of the essay. Takes us to point number two, which is worth 20% of this essay. Here, the bar examiners were looking for examinees to conclude that the act may be constitutionally applied to state agencies as employers because it regulates both public and private employers on the same terms. So our starting point rule when we're thinking about commandeering, right? Whether Congress is commanding the states to act or not. Because we know commandeering, the federal government cannot commandeer state action. They cannot command the states to adopt certain regulatory schemes. Right? This is New York v. United States. The Supreme Court held that Congress may not commandeer the states to regulate private conduct. Remember, in that case, this court struck down a federal statute that commanded states to regulate private disposal of hazardous waste. And it's important in this vein to always remember that Congress can use the taxing and spending powers to encourage state action. That's South Dakota v. Dole, where the federal government can condition a small percentage of federal highway funding on the adoption of a minimum drinking age, right? That's not commanding the states because it's just an incentive. It's encouragement, right? That's using the taxing and spending power to encourage state action. But when we get to where the federal government is commanding the states to take certain action, that's where it's a problem. That's not permitted. That's unconstitutional, right? Now, the issue here in this essay that we're given is that Congress isn't specifically directing the states to take action. What they're really directing is all employers everywhere to take these actions, right? All employers who have more than 50 employees are subject, right? All employers, including all states, are subject to this act, right? That was the key fact, really one word, all employers. So yes, state agencies that have 50 or more employees, but any employer has more than 50 employees is subject to the act. So the key here with point number 2 is recognizing, well, the federal government isn't directly targeting state agencies in the states. They're not directly compelling the states by themselves to take action. They're just saying, hey, look, all employers, which they are allowed to do. This is Garcia. If private actors and public actors are being treated even-handedly, right? Garcia upholds this type of federal statute, right? And Garcia, remember, the court upholds the application of the federal minimum wage and maximum hour law to both public and private employers. Because remember there, Congress is saying, hey, look, these minimum wage laws apply to all employers who meet this criteria. So if you're a state agency who's an employer and you meet this criteria, you have to follow this minimum wage law, right? And that's not commandeering the states because they're not directly targeting the states, right? They're saying all employers, including state agencies. That's the exact fact pattern we had here. That was point number 2. You really just had to know Garcia to know this one, right? Garcia v. San Antonio Metropolitan Transit Authority. That was pretty much exactly what this analysis was, right? Generally, we know that Congress cannot commandeer the states to regulate private conduct. However, if Congress is treating private employers and public employers even-handedly the same under Garcia, that is allowed. That's not commandeering because they're not directly targeting the states. That was point number 2, which takes us to point number 3, which was worth 30%. Here, the bar examiners were looking for examinees to conclude that the 11th Amendment bars the employee's lawsuit in federal court against the state agency because the act does not validly abrogate 11th Amendment immunity. So here you had to recognize kind of what triggers the 11th Amendment. Remember, anytime we have a private party suing a state agency, or a state official in federal court, right? That triggers the 11th Amendment. Here, this is exactly what we had. We had a private party suing a state agency in federal court, right? So the 11th Amendment was triggered. We have a private party suing a state agency in federal court. Because it's a state agency, not a state official, there's only 2 exceptions here we really have to worry about. And that's consent and congressional authorization, right? Of course, if the state agency consents to the lawsuit, they waive their 11th Amendment immunity, but we had no facts that the state agency wants to consent to the lawsuit. In fact, we see that the state agency has moved to dismiss the lawsuit on the grounds that the 11th Amendment bars the employee's lawsuit. So they're not trying to waive or consent to the lawsuit. They're doing the opposite. They're challenging this under the 11th Amendment. So really, that takes consent off the table. The only way that this would not apply, that the 11th Amendment state sovereign immunity would not apply here, is if we had congressional authorization. And of course, we did have facts, right? We did see in Section 204 of this statute, Congress does try to abrogate the state sovereign immunity clause. They say, right? Section 204 provides that any action brought pursuant to Section 203 may be brought in federal or state court, and if brought in federal court against a state, its agencies, or subdivisions, any defense of immunity under the 11th Amendment to the United States Constitution is abrogated. So they try to abrogate 11th Amendment state sovereign immunity. And if Congress does this clearly and expressly, if Congress clearly and expressly acting pursuant to its power to enforce the guaranteed protections of the 14th Amendment, if they're acting clearly and expressly pursuant to their power to enforce the guaranteed protections of the 14th Amendment, they can abrogate state sovereign immunity. So this really has like 2 requirements, right? You can think of this as like 2 elements. Number 1, it has to be clear and express, right? In the statute, they have to very clearly and expressly abrogate the state sovereign immunity clause, but they also have to do it pursuant to their power to enforce the guaranteed protections of the 14th Amendment. And that was the problem here. They were not doing that. We knew Congress was acting pursuant to Article 1, Section 8, Commerce Clause, right? That's where they're getting the power to pass this law. This isn't a civil rights type of case, right? That's where we see Congress is allowed to abrogate state sovereign immunity, right? That's what Fitzpatrick v. Bitzer is all about, where we get this idea of congressional authorization. And that's about like equal protection cases, civil rights cases, not the application of the Commerce Clause, right? So for that reason, Congress would not have been allowed to authorize this type of immunity, this state sovereign immunity exception. So there, neither exception applied, which is how you got to the conclusion that the 11th Amendment bars the employee's lawsuit in federal court against the state agency because the act does not validly abrogate the 11th Amendment immunity involved here. And also, we didn't see the state agency consenting. So because neither exception applies, and we have a private party suing a state agency in federal court, we know the 11th Amendment state sovereign immunity clause applies. So the state agency has immunity under the 11th Amendment, unless they consent, which they don't, or Congress authorizes otherwise, which we know was an invalid attempt here because Congress was not acting pursuant to its power to enforce the guaranteed protections of the 14th Amendment. That, again, was point number 3, 30% of the essay, which was everything that the bar examiners were looking for on this July 2012 multi-state essay constitutional law question. With that, I'll leave you all to it. I wish you all the absolute best, and I'll see you at our next lesson.